This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Ballmer, and today I'm excited to welcome Frank Ferrantello to the show. Now, Mr. Ferrantello is the president of Ferrantello Group Land Surveying, a full-service land surveying, civil engineering, and construction consultancy. He's a board member of the Nassau-Suffolk Civil Engineers and Land Surveyors and holds a bachelor's in civil engineering from Hofstra. Mr. Ferrantello, thank you so much for joining me here today on Engaging Experts.
Good day. Thank you for having me, Noah.
Absolutely. Let's jump into it. You've been in civil engineering since, the late 90s, it looks like. How did you first become involved in expert witnessing?
So I worked for my father's firm, very analog, very old school surveying. Surveying profession is very old, dates back to the ancient pyramids of Giza. And we modernized it. Back in 1999, I was the first land surveyor to use digital photography. When it first came out, I said to myself, I was taught to be and trained to be dynamic. So I figured, you know what? If we have this beautiful map or survey that's an exhibit, we put pictures on it, photograph exhibits, and they tell a story that's worth 10,000 words for jurors, for judges, for plaintiffs and defendants attorney, all to look at and really understand the existing conditions and the facts of the case. Because let's be honest, no one really knows how to read a map too well nowadays. When you look at a survey itself, it is so detailed, so intricate, and so forensic. I've been retained as an expert because of cases that started because of miscommunication or misreading a survey map.
So what were some of those first calls like? Were you aware of expert witnessing as a business? Were you expecting to get these sorts of calls? Did you seek them out? Or did somebody just call your land surveying company out of the blue and say, hey, we need an expert witness on this particular case?
You know what it was is they seek out a land surveyor, a professional land surveyor. But the majority of the profession, it's a very small profession. It's almost dying in one way because the average age of land surveyors are in the 70s. Right. My fellow board members are all 70s plus. And so there's not a lot of experience left. There's more technicians and geospatial technicians, right? A purveyor, a surveyor, a professional expert that knows the law, the statutes, the local laws. There's not many of them out there. So with my expertise and just producing a product that's legible, clear, has all the data, is not show and tell. We're doing the right job for the right reason. It talks for itself, basically. The product was sought out for many years from my father's firm, and then I just enhanced it and made it more clear, legible, and enhanced it with photographs and lines and illustrations just to clearly explain the facts.
So you receive a phone call from an attorney or the representative of an attorney, and they say, hey, we've got this case. We need somebody with your expertise. What are the sorts of questions that you ask them? Because it's a two-way vetting process. They ask questions, you ask questions, decide if it's a right fit. So how do you determine if you and the attorney are a good fit for an engagement?
Sure. So number one, I always do a conflict check. That's priority number one. So a lot of people try to get me first sometimes, and it's a matter of, doing a conflict check or working for a co-defendant. We're making sure we're conflict free. I like to work alongside the, some plaintiffs' attorneys can be kind of, how would I say, very aggressive and demanding, and they want results. And I'm not a hired gun. All right?
Sure.
I'm a sought out expert. Which is unbiased, and I know the law, and I know how to apply the surveying existing conditions, the forensic principles, and the statutes and law that I've tested on and how I got my license. So most people in layman terms, they don't know land surveyors need to know New York state law, environmental law, general obligation law, general business law, environmental, real estate, highway law. This is all part of the New York State specific exam. to get my license. I was going to become a lawyer at 40. And I said to myself, you know what? Why would I go back to law school? I'm a surveyor and an engineer. I wanted to become a lawyer also. I'm like, let them fight over me, not let them fight against me. Right. So I'm very well respected in the community, and it's just simply stating the facts. So I would like to work alongside with certain people and just want to defend the facts. It's based upon the facts.
Do you find yourself working in kind of an even split between plaintiffs and defendants, or does it kind of heavily veer on one side, and does that even matter?
About 50-50, more or less.
Is that important to you?
I don't have any preference over either side. It's just a matter of, I look at the case and I see, is this justifiable? Is this, something I want to put my name on? And if I can help the case out or not, and how the law applies.
Absolutely. Let's talk contracts for a moment. So when you are doing an engagement letter, do you have any specific terms that you like to make sure that get in there? Maybe it's a project rate or an hourly rate, or you take an upfront retainer. Are there any specific terms that you like to use to protect yourself?
I do. I have a standard retainer contract. It's important for me to be retained, paid for my time. And, listen, sometimes I have seen cases go on 12 years before they even call me, retain me, and they need a job by New Year's Eve in 1 week. Like, what happened? One law firm to another law firm over 12 years, no one hired an expert to see where the defect or the incident actually happened. 12 years? I've had them want it in like 2 days over a weekend. And I'm like, come on. There's some really great attorneys out there, but there's some attorneys that just, I don't know what it is. They wait till the last minute. And listen, that's the majority of the real estate professionals out there. They order the survey as the last thing, even though it's the most important. Whether there's easements, encumbrances, encroachments, out of possession, title, neighborly disputes, they all wait till the last minute.
Yeah, that's something that I've heard from other expert witnesses as well, that sometimes they feel that attorneys don't contact them until it's almost too late, or there might not be sufficient time for them to do their best work. Let's shift a little bit. You work in a field where you are dealing with very complex information. You were saying that a big part of your job is kind of parsing these maps and making sure that laypersons can potentially understand these arcane concepts in land surveying. How do you communicate complex concepts to the trial team, including your attorney, but also to a potential judge or even an impaneled jury?
So I'm very highly technical, so it is a challenge for me because it's my jargon, right? But I try to explain in simple terms, common sense terms, that, an easement is to ease the burden of one parcel or party against another. And what does that mean? It's a parcel of land, for example, that, you may have a driveway easement that's shared. It may mutually benefit both people, but it may also benefit one person and burden another party. So this is why it gives rise to disputes, because maybe there's an aggrieved party. Someone doesn't know the full gamut of the easement, of what the rights, title, and interest that they actually have. Someone may not take the time to show them or explain to them forget that even. Like, they have to research the actual original easement document and agreement to say what the limitations are of the agreement, because an agreement and the terms and conditions can state anything. I could own below the Brooklyn Bridge, and I could quitclaim it and certify that I own it. Doesn't really mean I can own it and I can occupy it. But there's certain principles like that where they often go overlooked, especially in real estate title transactions. But when it comes to Manhattan, New York City, there are so many laws, local laws. There's so many statutes that apply to expert cases like disputes, air rights, easement disputes, utility, losses and incidents, trip and falls, slips and falls, bus stops, pedestrian crosswalks, public and private development corporations developing plazas in front of the setback of high-rise and mid-rise buildings. They would have benches and tables and statues. Sometimes there's incidents where it's a public space, but it's really on private property.
Sure. How do you stay on top of it all with all of these, not only just a large body of laws and oversight, but an ever-changing body of law and oversight? How do you stay current?
Well, number one, continue education. Number two, always keeping my eyes and ears open. Any new cases, any principles that come through, any amendments to the statutes or case law, researching things on Westlaw or Thomson Reuters or, different legal platforms, but always being curious, like, why am I being retained in this case? How can I help? And basically, like, for example, there's new types of cases all the time, and I'm always setting a precedent in them because, for example, sidewalk liability is great and all that. People can slip and fall and trip and fall on a sidewalk defect, but is it within a certain area that may not be truly public? It could be a sidewalk that's got these crescents and marble tiles, and it was installed by a private and public development corp in conjunction with an agreement. So technically, it's not the adjoining landowner who installed it, and he or she is not responsible for it. So it goes back to the Plaza Department of New York City, DOT. If it's a pedestrian crosswalk, I've had cases that got lost before I got retained because they said, well, it's in front of the subject property and the tenant and or landlord is responsible for it. But it's a part of the public infrastructure. And because when it's in charge of the sidewalk, the landlord, I can understand liability for that. But when it's a traveled infrastructure and public pathway taken by hundreds of thousands of public pedestrians each year in front of someone's property on an intersection that's a public intersection of two city streets, common sense prevails. That wouldn't make sense that I'm going to be liable for that. I didn't install it. I don't maintain it. I don't use it. And so I've set legal precedent before by, again, looking at the confines of the law and the statutes, looking at amendments in case law, and just using common sense, just like the Supreme Court would, use common sense and certain principles to make new rulings.
As one of the areas of expertise that do necessarily involve the law, does that ever lead to friction with the engaging attorney who's in fact a lawyer? Do you have different interpretations of the law or different theories based on the facts at hand? Does that cause any friction?
Of course, attorneys don't like to have bad news, but it's about looking at a case and seeing where I could zoom in on. And, if you look at a case where, for example, a sidewalk joint between two sidewalk flags or sections, it may be almost infinitesimally small, but, I always ask the attorney to review the survey results, review my findings face to face, and zoom in, look at all my data, and I can understand that and I can help you do that. But I need to know really, I look at the summons complaint, I look at the transcripts, the depositions, I look at a lot of different legal documents and exhibits from the case. But when you talk face to face to the attorney, then you can understand the story a bit better. You can really zoom in and hammer home. Okay, now I understand better. What occurred? Is this the uplifted sidewalk or the other one subsided and sunk and fell?
Sure.
So there's two ways of looking at it. So you got to really kind of retrace the defect and the cause and effect. It could be a drainage pipe. It could be an old root that decomposed and the root's no longer there. And so it sunk the sidewalk flag and section. And that gave way to a proper sidewalk, proper level and compliant, but the other side has a negligent sidewalk that sank,
right,
exposing my client's potential sidewalk. And that creates a trip hazard.
Let's shift a little bit and talk about preparation. So you have a big day, a big case. It might be a deposition. It might be a trial, whatever the case may be. How do you get ready for the big day? I've had expert witnesses tell me they like to review all of the materials. And then I've had some more intangible things. I like to do yoga. I like to drink a lot of coffee. I like to fast. What does your preparation routine look like when you're getting ready for any potentially big day?
Blood flow is good, right? Blood flow is always good. So getting to the gym, getting early start, getting hydrated is important. Having my support team help me, guide me, have all the facts in hand. And just, again, I may retain a lot of information. I do. It's been certified in court, my memory, but I'm only human. No one's getting younger. Clock not going backwards, right? It's only going forwards. It seems like it goes faster with each month and each year going.
Do you have a story or two or a case or two? Obviously, you don't have to give the details to reveal the client or anything, but that either reinforce something that you do already as an expert witness or change the way that you go about doing some aspect of expert witnessing? Do you have any kind of tent pole cases?
I have just a wealth of knowledge on a case, and sometimes it's just too much information for people. Maybe under cross-examination, sometimes less is more. I've been very successful in conveying the facts of the case, because sometimes when an expert's under cross-examination, the other side, whether they retain me or not in another case or not, they want to disqualify me. They want to Daubert me. They want to distract me. They want to disorientate me. And, a lot of times I have a great comeback, and, they're trying to snatch you on something, right? So less is more sometimes. And, when I do have to expand on a principle or something like a fact of the case and a principle like why I feel this way based upon my survey of existing conditions and my findings, is because, I have a lot of experience, and the way I was taught and the way I learned was, who's to say I'm right? Maybe I made a mistake, but, I like to have, especially in my procedures, like a litmus test. If I had to present this in court, every single step, why am I right? Why am I correct? Based upon what factual evidence, legal evidence, am I right? And because I have been questioned, I have been disputed many times from normal property owners, from land use, from zoning attorneys, just from builders, developers that may be very successful, and they just think because they're successful, they're always right.
Mm-hmm.
But
Sure.
most of the time, I would say 85 to 90% of the time, they don't have any factual based legal evidence. They don't even have an old survey that's relevant. It may be from the 1950s. It may be outdated. It was chopped up and sold off piecemeal. So, I have all the knowledge. I have all the facts, and it's very rewarding presenting them all. I just have to be careful I don't say too much, because sometimes people will chew on that and try to get you on something. So sometimes less is more. And when I have to expand on something, I have to explain it in layman's terms.
As somebody who's been doing this for a long time, do you run into situations where the other side wants to impeach you on things that you've said before, either take something out of context or look at something that you wrote 20 years ago, then maybe just the facts have changed or your opinions changed? How do you deal with those sorts of situations?
I've had people accuse me of, what makes me an expert if I worked for my father for so many years, but I've been working more for myself as an expert longer than I worked for my father. And because it's a predecessor firm, my father's experience or teachings or training as Bible, as written in stone. I didn't agree with some of it. I like to do a very diligent approach. I've had to deal with politicians, attorneys, public hearings, members of the board, opposition, neighboring adjoiners and neighboring owners that they hire their own counsel to go against and oppose a certain application or project or self-storage building. And so I have to have those facts. So I want to be very diligent, all the information at hand, and you got to be very organized. That's the key.
Sure.
We have all this technology. We have all this ability to collect information nowadays, and information and data is powerful. So I always like to get everything, organize it. And the easier you organize it, the easier it is to convey it and retain it. for yourself.
Do you have any specific organization tools that help you? Do you like any specific apps, or you paper and pen guy? How do you like to get organized?
I like to keep things digital, just because they're always at the fingertip in the cloud. They're always, if there's some mobile, if it's an email. I just like to be clear. The more detailed, the better, because you can search by almost any terms. So you don't want to miss a beat. As a surveyor, not just an expert, I deal with all types of clients, and I mean all types of clients. So some architects will, they'll call it the Smith residence. A title company will have a title number to reference by. Internally, project management wise, we'll have a job number. The attorneys will have the title of the case, the capture from the court. So there's a lot of different facts that you have to go by that represent and catalog and categorize the project or case.
Before we wrap up, do you have any last advice for expert witnesses or attorneys that are working with experts?
I would just say you have to be organized, you have to be consistent, you have to be detailed, and you have to be relatable. You have to be able to explain it so the jurors, the judge in a bench trial can all understand and relate with what you're saying. So many people have neighborly disputes with fences and easements and driveways. Same things may apply to many expert cases. And, a lot of it comes down just to being relatable and common sense.
Sage advice. Mr. Ferrantello, thank you so much for joining me here today.
Thank you, Noah. It's a pleasure.
And thank you, as always, to our listeners for joining us for another edition of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.